Good evening, ladies and gentlemen. I'm hearing audience applause in the background. That's what goes on in my head all the time. It's very quiet in here. It's like talking to myself. Welcome to Night Court, the only court in session where the judge doesn't bang the gavel, but instead asks, how long do we have to sit through this one? I'm your host, your late night bailiff, your courtroom jester, just without the tights, JT, and tonight we've got a docket more packed than a DUI lawyer's briefcase full of regrettable decisions. Actually, you'd never know if I was wearing tights or if they were involved in not, would you? Makes you think. Brain bleach. And folks, we have some serious stuff to unpack from last week. It's like the legal system threw itself a party and forgot to invite common sense. Take, for instance, the case of the fellow who tried to rob a bank but forgot to bring a mask. He just kind of waltzed in there and went in to open a savings account and instead tried to withdraw, everything. In the court, the prosecutor said, sir, we have you on 15 different cameras. The defendant said, well, I wasn't really robbing a bank. I was auditioning for a role. The judge said, really, a role? Well, you're about to be cast as inmate number 8675309. Congratulations. Method acting it is. Then there's Travis Jones, who thought he could rob a lingerie store naked. Yeah, the guy walks in like, I'm here for a stick-up, but not because I have a gun in my pockets. Clearly. I mean, Travis, buddy, if you're going to commit a crime, at least wear some pants. Unless that's what he was going for. I can't decide if he was being incredibly stupid or just being a pervert for Sherbert. But here's the best part. He tried to blend in after, as if no one's going to see him in the sea of silk lace and oddly sexy mannequins. My man, I know getting naked was the secret Victoria was trying to tell, but it does not make you invisible. And unless you're trying out for the runway, that's not blending in. And, sir, you're no Heidi Klum. Although, if he was looking for a whole new level of exposure, that's one way to do it. Which, by the way, is exactly what we're here for. We're here to expose the last week and explain the upcoming one. I've got your back, folks, and the staff has mine. I think. Depending on the day. No. Got the best staff ever. All right, Night Owls, get comfy and settle in because it's time to bring the gavel down on this week's courtroom circus. Let's hit the street. All right, it's time for Word on the Street. Let's talk about the North American Wife Carrying Championship for a second. Can't say it's news per se or crime-wise, but listen, of course it's a thing here. Every year, dozens of couples gather in Maine to run a grand total of 278 yards through mud, water, and logs, while the husband carries his wife like a sack of potatoes. No, it makes sense because their wives have been carrying them for years. The whole event is based on a 19th century Finnish legend about a robber who used to pillage villages and carry away the women. So, yeah, the origin story is just about as romantic as it sounds. But hey, it's all for the grand prize, beer and cash. After hauling your partner through mud and water, definitely need a drink. Probably a good couples therapist. And if you think that's weird, a woman in Kitsap County has been feeding a small family of raccoons for years. Just a few here and there, but recently things escalated faster than a Costco sample giveaway. Don't act like you don't know what I'm talking about. She went from feeding a handful of raccoons to basically running the Golden Corral for 100 of them. Literally. And let me tell you, these raccoons weren't just showing up for dinner. They were getting aggressive. They were scratching her door, surrounding her car, demanding food like furry little masked mobsters. It's like a Disney movie, but instead of singing woodland creatures, you have a chorus of raccoons hollering, "When you're a rack all the way, from your first dirty trash can to the woman's canned spam." The sheriff's office came out, assessed the situation, and said, well, technically no laws were broken, which is definitely the nicest way of him saying, lady, this is entirely your fuck up. So now she's living in a real life raccoon apocalypse. I don't know about you, but if I'm negotiating with raccoons, probably time to move. Finally, word on the street is that Switzerland is the land of chocolate, neutrality, and apparently timed bathroom breaks. That's right. A Swiss court has ruled that employees at a watch dial factory had to clock out to use the bathroom because, time is money. Literally. So if you work there and need a bathroom break, you're not just answering nature's call. You're also punching the clock like it's Fight Club. Employees have to stand there wondering, do I hydrate and risk losing this is not, I don't know, Swiss, not my thing. Risk losing a paycheck, or do I dehydrate and preserve my sweet, sweet Swiss francs? Apparently, the company said their employees have a great deal of freedom during their breaks. Sure, as long as that freedom doesn't include basic human functions. This is a country famous for its efficiency, but come on. Even Swiss watches get a rest. You'd think the people making them would too. But here's the best part. Swiss law doesn't even mention the right to go to the toilet, which means lawmakers might actually have to pass legislation just so people can, pee. So I guess we're waiting for the day the Swiss parliament is debating toilet rights while someone's in the back row crossing their legs. Hashtag still got more done than U.S. Congress. Wow. Whew. What an opening, huh? Let's go ahead and get into the brief. Grab your gavel and popcorn, possibly your milk duds, because night court is in session. And this one's gonna be a doozy. Let's get into it. So, last week, in our case in chief, we explored the dark and quite literally twisted tale of Sarah Boone. Sarah is facing a second-degree murder charge related to the 2020 death of her boyfriend, George Torres. She is accused of murdering her boyfriend after a fatal game of hide and seek. George was found dead after being left in a suitcase overnight, and cell phone footage captured by Boone herself showed her taunting him and refusing to let him out. On Monday, Boone rejected a plea deal from prosecutors that would have reduced her potential sentence to 15 years if she pleaded guilty to manslaughter. If Sarah is convicted of murder, the minimum sentence is 22 and a half years. The trial set to begin with jury selection. It was set to begin with jury selection last Monday, but the case was delayed again for the 16th time due to Hurricane Milton. Boone's ninth and current attorney, James Owens, had previously requested a delay in the trial. Oh, what a guy. He said that the hurricane seems like divine intervention. I mean, what are the odds of a hurricane coming to Orlando right in the middle of this trial when the judge had a set fixed date? He was not going to change it except exceptional circumstances, Owens told the Orlando Sentinel. Now, jury selection set to resume tomorrow, October 14th. The trial is expected to take 2 to 3 weeks, and the world is wanting to know, will Sarah Boone take the stand and testify on her behalf? Oh boy, do we at Night Court hope so. We will be covering this case extensively, so be sure to subscribe to the YouTube channel and follow us on social media. And you can find all of our links in the descriptions below so you don't miss any Sarah Boone updates. Next, we have the man, the myth, the person most voted in high school as most likely to single-handedly keep Johnson's baby oil in business, Sean Diddy Combs. You know him as Puff Daddy, P-Diddy, Diddy, Sean John, or the artist formerly known as Dicks, Rubber Dicks. 784 rubber dicks, which is almost enough dildos to fill all the holes in his alibi the night Tupac died. Born in Harlem, New York, Sean Combs carved out an empire from the gritty sheets to the glitzy suites of hip-hop royalty. With Bad Boy Entertainment, Combs produced hits for the likes of the Notorious B.I.G. and Mary J. Blige, revolutionizing rap in the 90s. He's a rapper, producer, entrepreneur, actor, and let's be honest, at one point he was even a fancy vodka salesman. But Combs isn't new to drama. In fact, it's almost like it follows him around, or his Google Maps is consistently set up to navigate the local courthouse. One or the other. Remember that nightclub shooting back in '99? That was Combs, who, along with Jennifer Lopez, yes, Jenny from the block, was arrested after a gun was found in his car. He was acquitted, but his mentee Shine wasn't so lucky. Fast forward to 2015, and we saw Combs arrested again, this time for swinging a kettleball at his son's UCLA football coach. I mean, hey, if you're going to rage, why not go full gym rat? I guess. He's no stranger to courtroom theatrics, but this latest saga takes the legal drama from Broadway to soap opera, but with 1,000 bottles of drug-laced baby oil. It would be aptly titled The Young and Consentless. In September of 2024, Combs was hit with charges that make even Hollywood's wildest crime dramas look as tame as lamb chop in a Monday morning slot on PBS. Racketeering conspiracy? Check. Sex trafficking? Check. And we're just getting started. Combs allegedly ran what prosecutors have dubbed Combs Enterprise, which is not your run-of-the-mill Fortune 500 company. We're talking about a criminal operation spanning a decade, involving forced labor, kidnapping, bribery, and even arson. But wait, there's more! Get away, ShamWow guy. He also allegedly organized something called freak-offs, even though it sounds like the next bad reality TV show that even TLC wouldn't greenlight. In reality, it involved transporting commercial sex workers across state lines for multi-day sex parties. According to the feds, Combs used his power, money, and influence to coerce women and men into these events, with some terrifying allegations of physical abuse, control through drugs, and even blackmail with sensitive videos. Combs, naturally, has pleaded not guilty. And while his lawyers are gearing up for a defense, he's stuck behind bars without bail because apparently the court isn't too sure he wouldn't just vanish into the luxury lifestyle and never come back. Combs faces life in prison if he is convicted. He made his first appearance in court this week. He appeared anxious at times in the packed courtroom, turning to his supporters in the gallery, including his mother, Janice Small Combs, and his children. Upon the end of Thursday's hearing, Combs waved to his family, threw them a kiss, and gave a prayer motion before being led out of the courtroom. The federal trial is scheduled to start May 5th, 2025, and it sounds like we're in for a hell of a courtroom spectacle. Of course, it's federal, so we can't watch it, which means you're just going to have to come here for the updates because, you don't have the internet or anything. A case that has captured the attention of millions, the disappearance and death of 20-month-old Quentin Simon. His mother, Leilani Simon, now stands trial for his murder. It's been 2 years since baby Quentin went missing from his home in Savannah, Georgia, on October 5th, 2022. Leilani Simon, his mother, reported him missing, sparking a massive search effort involving law enforcement, volunteers, and community members. In the following days, she reportedly misled authorities, claiming she had no idea what happened to baby Quentin. Law enforcement sources revealed that her statements were inconsistent, prompting a deeper investigation. Sadly, a 6-week search done by CCPD and the FBI ended in heartbreak when Quentin's remains were found amidst debris in a dumpster located at a nearby landfill weeks later. The discovery was a tragic confirmation of everyone's worst fears. The investigation quickly turned its focus to his mother. Leilani Simon was indicted on 19 counts, which accused Simon of malice murder, felony murder, concealing the death of another, and 14 counts of making false statements. Looks like she was trying to take a page out of the old Casey Anthony playbook. Prosecutors allege that Leilani not only took her son's life, but also attempted to cover up the crime by disposing of his body in a dumpster. In court, Leilani's defense team has continued to fight for her. They've taken measures to challenge the inclusion of what they consider to be prejudicial evidence. These include police recordings where she was interrogated shortly after Quentin's disappearance, and 911 calls that might shed light on her behavior and state of mind. They argue these materials could unfairly bias the jury. The prosecution, however, is determined to include these as critical pieces of evidence that could provide insight into her potential motive and actions. Reports from jail suggest that Leilani Simon has expressed frustration and dissatisfaction with her current circumstances. Sources reveal that she has complained about the difficulties she faces while awaiting trial, even describing her life as tough. Gee golly, gee willikers. Critics argue that the complaints show a lack of remorse and highlight her detachment from the reality of what she's accused of. On Friday, prosecutors and defense attorneys whittled down a pool of nearly 100 potential jurors. Attorneys on both sides are ultimately trying to determine what, if any, opinions each potential juror had and whether they could render a verdict based on the evidence presented during trial. Many jurors during questioning said they had watched news coverage of this high-profile case. A jury of 12 jurors and 4 alternates were seated for the Leilani Simon trial. One person who made it onto the jury works at Waste Management, which runs the landfill where Quentin was found. The supervisor of the landfill is expected to testify, and that juror said he knows of that person. Leilani's trial has been a source of controversy and pain, not just for her family, but for the public who have followed every detail. Many are waiting for justice for Quentin, a child whose life was taken far too soon. Court is set to begin Monday morning at 9 a.m. Eastern and will be televised. We will be covering this case extensively, so be sure to subscribe to our YouTube channel and follow us on social media. You can find all of our links in the descriptions below so you don't miss any of the updates. The next case is Georgia v. Melody Walker Ferris, better known as the Burn Pile murder trial. This centers around the mysterious and brutal death of Gary Ferris, a well-known attorney, allegedly at the hands of his wife, Melody. The story begins in 2018, when Gary Ferris was found dead, his body burned on the couple's property in Cherokee County. Initially, authorities believed it may have been a tragic accident. However, their theory quickly shifted to murder when a bullet was found lodged in his ribs. Melody Walker Ferris, Gary's wife of nearly 40 years, was arrested for the crime, with prosecutors arguing that she shot her husband, then attempted to cover it up by burning his remains. The prosecution has made their case clear. Gary and Melody were in a strained marriage marked by financial disagreements. Gary controlled the couple's money, and there were allegations that he refused to give Melody funds, preferring instead to support their adult children. At the same time, Melody was involved in an extramarital affair with a man named Rusty Barton. The prosecution presented evidence that Melody called Barton on the night of Gary's death, telling him chillingly, "He's on the burn pile." This statement alone sent shockwaves through the courtroom. Investigators found critical forensic evidence linking Melody to the crime scene. Blood and ash were found on her clothing, and a spent bullet was recovered from the couple's basement. Although the gun used in the murder was never found, investigators determined the bullet was from a .38 caliber firearm, consistent with the injuries Gary sustained. The forensic evidence played a major role in building the case against Melody, portraying her as the orchestrator of this grisly act. One of the most intense moments in the trial came when Gary and Melody's son, Scott Ferris, was called to the stand. In a dramatic turn, the defense team cross-examined him about a missing gun from his personal collection. It became a key point, as it was the same caliber as the bullet found in Gary's body, and it had not been reported missing, raising the possibility that it could have been used in the murder. The defense went even further, asking the son directly if he had killed his father. The tension in the courtroom was palpable, as the son denied any involvement, but the insinuation added an unexpected twist to the defense's strategy. The question was meant to cast doubt. If Melody didn't have the murder weapon, could someone else in the family have committed the crime? There was no shortage of drama in this trial, especially during the cross-examinations. The defense team repeatedly tried to poke holes in the prosecution's case, focusing on inconsistencies in the forensic evidence and pointing out the lack of a murder weapon. The defense suggested that the blood on Melody's clothes could have been the result of secondary transfer. This means that the blood may have been transferred to her clothing accidentally, either from being in the vicinity of the crime scene or from handling objects with Gary's blood on them without being directly involved in the murder. They also attacked the credibility of the investigation, suggesting that law enforcement might have overlooked crucial pieces of evidence, such as not adequately testing fingerprints or other forensic evidence on key objects like the bullet found in the basement. An additional argument was that the crime scene was not properly preserved, suggesting that investigators may have unintentionally disturbed or overlooked important evidence in their haste to gather materials, particularly around the burn pile and within the house. As we continue to follow this trial, it's clear that the jury has a tough decision ahead. Did Melody Walker Ferris kill her husband, as the prosecution claims? Or is she innocent, as her defense insists? The case against her is built on circumstantial evidence, but the defense has raised questions that could potentially sway the jury. The trial is ongoing, with the prosecution still arguing its case in chief. The trial is expected to continue over the next 2 to 3 weeks, so be sure to join us here next week on Night Court and every Sunday at 8 p.m. Eastern, where we will give you all the court drama deets. The tea, as it were. Now, speaking of case in chief, I think it's about time that we hop into that. And it's a marathon, so start stretching. On last week's episode of Night Court, we briefly dived into the controversial case of Indiana v. Richard Allen, better known as the Delphi murders trial. This week, we want to dive deeper into what has been going on in the courtroom since Allen's arrest. But before we do, let's do a little recap. On February 13th, 2017, in Delphi, Indiana, 14-year-old Liberty Libby German and 13-year-old Abigail Abby Williams were dropped off at a local nature trail by Libby's sister. When they didn't return home later that evening, the girls were reported missing. The next day, on Valentine's Day, their bodies were discovered about a half mile from the trail they were last seen on. Both girls had their throats cut. Their clothing was either swapped or missing, and their bodies were covered with sticks. Their murders shocked the country and changed their families and their small Midwest town forever. Libby managed to capture a brief video and audio recording of a man approaching them on her phone, including the now infamous bridge guy saying, "Guys, down the hill." For years, investigators released sketches of potential suspects, but no arrests were made. The video and audio recording remained central to the investigation. It wouldn't be for another 5 years before police made an arrest. On October 31st, 2022, a man named Richard Allen, a Delphi resident of many years and a CVS employee, was arrested and charged with the murders of Abby and Libby. He is currently facing 2 counts of murder and 2 counts of murder in the commission of kidnapping. Both charges carry the same penalty, but he can only be sentenced on 2 of the 4 counts if he's convicted. If convicted, he faces between 45 and 65 years in prison for each of the convictions, meeting a sentencing range of between 90 and 130 years. According to the arrest affidavit, investigators tied Allen to the case in part after identifying an unspent .40 caliber bullet less than 2 feet from one of the girls' bodies. Lab analysis later confirmed the same bullet had been cycled through a pistol that Allen purchased in 2001 and which police recovered from his home. Allen, who told police that he never let anyone borrow his gun, said he had no explanation for how a bullet linked to his weapon might have ended up at the scene. He also denied knowing either girl and said he was not involved in their deaths. Allen was among the trail visitors that day whom police interviewed early on. During his 2017 interview with a park ranger, Allen allegedly told them that he was on the trail between 1:30 and 3:30 p.m. and claimed to have been on another bridge when he saw 3 females. Those girls told police they remembered passing by a man whom they described as, quote, kind of creepy. One of the girls tried to say hi, but the man didn't respond, but instead glared at them. Another woman told police she saw a muddy and bloody man walking west on a county road just before 4 p.m. The man appeared to have gotten in a fight. Allen pleaded not guilty and was denied bail. It was during that hearing that Carroll County prosecutor Nicholas McLeland said in court that Richard Allen may not be the sole suspect. Attorneys Bradley Rozzi and Andrew Baldwin were appointed to the case. And since then, the courtroom drama has been in full swing. Rozzi and Baldwin's first battle was regarding custody concerns. Richard Allen had been in the custody of Indiana Department of Corrections since early November 2022. This served as a safety precaution due to him being a high-profile inmate. He was put into solitary confinement at the Wabash Valley Correctional Facility, maximum security state prison some 140 miles away from Delphi. Usually, pretrial detainees are kept in a local county jail until they are convicted and sentenced. In April of 2023, Allen's legal team filed an emergency motion to modify his safekeeping order, claiming that the suspected killer was not being treated like other detainees, mistreatment by prison guards, and the deterioration of his mental health. This motion, however, was denied. An additional issue facing the defense is the fact that Allen has allegedly confessed to killing Libby and Abby more than 60 times since his arrest. Many of the confessions were made to his wife and mother, and some contain details only the killer would know, prosecutors said. In a pretrial hearing, Brian Harshman, a state police detective, testified to hearing Allen make dozens of confessions to family members during more than 150 hours of conversation. According to Harshman, those confessions began in March of 2023 after Allen had a, quote, come to Jesus moment and started reading a Bible in his prison cell, proclaiming to have found God. Harshman said Allen expressed a wish to atone for what he'd done to the 2 girls so he could one day be reunited with his family in heaven. During a phone call on April 3rd, 2023, Richard Allen allegedly told his wife, Kathy Allen, several times that he killed the 2 girls. Allen's wife and mother reacted with disbelief, anger, and shock at his confessions. Harshman said telling Allen, they're messing with your mind, or stop talking about it. Harshman testified that Allen expressed fears his family would no longer love him after the trial, particularly after seeing graphic images of the girls' bodies. In one alleged confession, Allen claimed In one alleged confession, Allen claimed he killed Libby and Abby with a box cutter and later disposed of the murder weapon in a dumpster outside of his work, per the prosecution. Indiana State Police Lieutenant Jerry Holman also testified that Allen had confessed directly to him, as well as to other fellow inmates. Allen's defense team, meanwhile, contends that their client's confessions were false and the result of an apparent steep decline in his mental health. The defense claim from the months of March 2023 to June of 2023, Allen was suffering from a case of stress-induced psychosis that was triggered by being unjustly locked in solitary confinement for months on end and treated like a, quote, prisoner of war. It was even reported by prison guards that Allen was banging his head on the wall to the point that his face was severely bruised. The defense has laid out a timeline of Richard Allen's mental decline, saying that On March 23rd, 2023, Allen was depressed and withdrawn and said he was not straight in the head. April 4th, 2023, Allen suffered from insomnia and hopelessness, was suicidal, and stated, quote, death would bring relief to him. April 13th, 2023, Allen was exhibiting bizarre behavior, including consuming his feces, and was suffering from a grave disability. The prison psychologist ordered Allen to receive an involuntary injection of psychotropic medication. April 21st, 2023, Allen's thoughts were disjointed and he was saying strange things. Walla discussed that he might be considered incompetent to stand trial. May 3rd, 2023, Allen said he wanted to confess details of the crime. May 18th, 2023, Allen receives another dose of psychotropic medication. May 23rd, 2023, Allen was diagnosed as suffering from stress-induced psychosis. June 8th, Allen's depression was reported to be at its peak, with trembling and knees buckling noted by a psychologist. June 15th, Allen receives another dose of psychotropic medication. At the end of June 2023, Allen's mental health is improving, and in October of 2023, Allen begins proclaiming his innocence. At the end of July this year, during a pretrial hearing, Dr. Monica Walla testified that Allen's mental health began to deteriorate in April of 2023, days after his first reported confession. According to Walla, Allen started expressing suicidal thoughts and feelings of hopelessness. Allen's attorneys pointed to Walla's testimony as evidence their client was in the throes of a mental health crisis when he confessed to killing Libby and Abby. They claimed Allen was coerced into falsely confessing due to the extreme conditions of his pretrial incarceration. However, Dr. Walla also expressed concerns that Allen may have been faking some of the psychotic symptoms. In her notes, she seemed to question whether Allen was purposefully behaving bizarrely. Walla acknowledged there were times she was not certain whether Allen was legitimately going through a mental health crisis or feigning psychotic behavior. She also testified that Allen confessed to her that he committed the murders of Abby and Libby. Detective Harshman also testified that prison guards assigned to keep an eye on Allen when he was on suicide watch did not believe his symptoms were real. Despite the defense's claims regarding Allen's mental state, at no time has a competency test been ordered by his attorneys or the judge to assess the severity or legitimacy of his reported psychosis. Now, on September 18th, 2023, Allen's attorneys, Baldwin and Rozzi, dropped a bombshell 130-page motion with some stunning allegations. This motion laid out, in their opinion, the reasons the search warrant for Allen's property should be thrown out. They requested a Franks hearing, alleging that investigators withheld information from a judge in order to get the warrant approved. But the filing went well beyond that and laid out the defense's extraordinary alternative theory that killings were linked to a cult. The theory involves several members of a purported Odinist cult operating in central Indiana. Odinism itself is an ancient Nordic religion, sometimes known as Asatru. While often peaceful, some adherents practice animal sacrifice and ritualistic killings. And in recent years, some white supremacist groups have co-opted the religion, making it an overtly racist ideology. Allen's attorneys believe followers of the religion ritualistically sacrificed Abby and Libby. They pointed to the crime scene itself, in which the girls' bodies were posed and tree branches were intentionally placed in a very specific and arranged pattern on and around their bodies. Someone used blood matched to one of the girls to paint a symbol similar to the letter F on the trees. The F symbol is associated with Odinism beliefs. Alan's attorneys believe the slayings were the work of more than one person. They don't believe Alan had the time or ability to carry them out by himself. The filing devotes nearly 60 pages to a wide-ranging conspiracy involving individuals who were purportedly members of a cult-like group. They believe these alleged cult members were involved in the teens' deaths. One of the men had a son who dated Abby Williams. Defense attorneys also cast doubts on alibis offered by the purported cult members, along with inconsistencies in their individual stories. At least one of the alleged cult members knew details about the crime scene that weren't public knowledge. Another, the filing said, was the subject of a tip to investigators just 2 days after the girls' bodies were found. The individual was allegedly a member of Vinlanders, another term for Odinist followers, and posted social media photos of half-dead women and strange symbols made out of tree branches. The attorneys also wrote that Richard Allen has no known ties to the group of any white supremacist ideology. But the Odinist connections don't stop there. In their motion to have Allen moved to a different facility as he awaits trial, Baldwin and Rozzi said prison guards wore patches that appeared to show Odinistic symbols, including one that purportedly said, "In Odin we trust." During later interactions, the guards no longer wore the patches, the attorney said. The attorneys contended Allen had been monitored by guards with ties to Odinism during his time in captivity, with the guards using tasers against him on multiple occasions. 2 guards in particular were almost always by Allen's side and within earshot of conversations involving Allen, his attorneys, and his wife. Their close proximity to Allen and alleged ties to Odinism make it impossible for Allen to discuss things openly with his defense team. The Carroll County Prosecutor's Office deemed the Odinist cult killing theory unfounded, with absolutely no proof. In a motions hearing in early August of this year, Don Perlmutter, director of the Pennsylvania-based Symbol Intelligence Group, and who wrote a book on ritualistic crime scene investigation, said the teens' deaths have all the elements and are textbook examples of ritualistic murder. Branches were placed on the girls' staged bodies in a way that resembles symbols, Perlmutter said. They were found in the woods near a body of water, and their throats were slit, both of which, she said, are typical of killings perpetrated by people with magical beliefs. Perlmutter, however, acknowledged during intense questioning by prosecutor McLeland that her findings were based on a review of a limited set of evidence. She said she reviewed autopsy records, crime scene photos, and social media posts of some of the alleged Odinists that showed images of runes and symbols. But when questioned by McLeland, she acknowledged she did not examine other pieces of evidence, including Allen's confessions to the crime. She also did not look at the alibi of Brad Holder, a Logansport man who the defense alleges should have been the primary suspect. McLeland further pressed what Perlmutter's response would be if she learned that Allen said the intent was sexual assault, and, quote, said that the branches were there to cover the girls' bodies, not an example of symbolic runes. McLeland also sought to discredit Perlmutter by eliciting testimony that she reached the same conclusion a year ago when she appeared on court TV and before she even saw any evidence in the case. Testimonies elicited by the defense sought to reinforce their theory that someone else other than Allen killed the girls. But with witness after witness, McLeland drove home the point that there was nothing tying the alleged Odinists to the crime scene. Kevin Murphy, a former Indiana State Police detective who looked into the Odinism angle, testified that the early consensus among investigators was that 2 to 6 people were involved in the killings. Murphy, who was involved in the case from 2017 to 2019, focused his investigation mainly on another alleged Odinist whose sister told investigators that he confessed to the crime. Elvis Field's sister, Murphy, testified, provided Elvis Field's sister Murphy testified, provided very specific information that only someone who was at the crime scene would have known. Murphy also recalled a recorded phone call between Fields and his sister, during which she blurted out, quote, "Elvis, why did you kill those girls?" Fields denied killing the girls when interviewed by detectives, but Murphy recounted an interaction that caught him off guard. After Fields consented to a swap test, he asked Murphy if he would get in trouble if his spit was found on the girls. Referring to a cryptic picture that Brad Holder, the other alleged Odinist, shared on Facebook, Murphy said a post showing symbolism mimicking a crime scene is not a coincidence. Murphy, though, acknowledged there was no physical evidence linking the men to the crime. Fields' phone also remained in Rushville at the time of the murders. Todd Click, a former police officer for the Rushville Police Department, who helped Murphy with the investigation, said he believes the girls were killed after inadvertently walking in on an Odinistic ritual. He said he believes Holder and another alleged Odinist, Patrick Westfall, were on the Manon High Bridge Trail the day the girls were killed, although he acknowledged there was no smoking gun linking them to the crimes. Amber Holder, who was briefly married to Brad Holder in 2018, testified about Westfall's confession that he killed Abby. But Amber Holder also admitted she only heard about the supposed confession from her ex-husband, who was drinking at the time. One of the most haunting images of the crime scene has been leaked to the public, and that's of Libby's blood on a tree. Defense attorneys have alleged that the killers used Libby's blood to paint a letter F, another clue tying the crimes to Odinism. But an expert witness from the prosecution sought to discredit that theory. Major Patrick Cicero, a blood specialist and forensics expert from the LaPorte County Sheriff's Office, who was consulted by the state earlier this year, said the letter, which he said looked more like an upside-down L, was likely a transfer stain that resulted from contact with Libby's bloody hand. Cicero said painting the letter using Libby's blood would have been impossible and would have required repeatedly dipping into the source of blood. Cicero, when questioned by defense attorney Jennifer Jones Auger, acknowledged his testimony just provides an alternative explanation, and he does not know how Libby's blood made it on the tree. Cicero also spoke in detailed and disturbing testimony about the girls' final terrifying moments of life. Having reviewed crime scene photos and other documents, Cicero testified that Abby Williams likely was murdered while lying down. Libby, meanwhile, was cut while standing and eventually sat down. He further testified that the position of Libby's body suggested she's been dragged by one arm to where the killer eventually left her. He didn't believe her body positioning was staged, more so the results of how Libby was moved. During this same hearing, Allen's defense team accused investigators of intentionally keeping evidence that could prove their client's innocence as they sought to convince Judge Gull to dismiss the case against their client. Andrew Baldwin zeroed in on Brad Holder, a Logansport man who he argued has ties to Odinism and had cryptic Facebook posts that connected him to the crime scene, and who should have been a primary suspect in the deaths of Abby and Libby. Instead, Baldwin said, Holder was never meaningfully questioned by law enforcement, and the contents of his phone were never extracted. even though investigators obtained data from the phones of 101 people during their years-long investigation. According to Baldwin, these included every Tom, Dick, and Harry that had nothing to do with the case, but not Holder, whose son dated Abby Williams, and who had posted an image of runes on his Facebook page that Baldwin claimed resembled the way in which one of the girls' bodies were arranged. Quote, "This isn't what we're up against," he said. This is what we're up against, he said, adding later, "There is intentionality on the part of law enforcement to keep evidence from us. Allen is never going to get a fair trial." Police cleared Holder during the early stages of the investigation and was never charged. Indiana State Police Lieutenant Jerry Holman, one of the key investigators, testified about Holder's alibi on the day the girls were killed. Investigators believe the murders happened between 2:30 p.m. and 3:30 p.m. Holman testified that employee records show Holder, who worked at a landfill about a half hour away from Delphi, clocked out at 2:45 p.m. He then checked in using a key fob at a gym in Logansport at 4:08 p.m. Kevin Murphy, a retired Indiana State Police officer who worked on the Delphi case from 2017 to 2019, said that while other investigators did not consider Holder a suspect, he and two others did. He said that there was an undeniable link between Delphi and supposed Odinists from Rushville. On September 4th, 2024, Judge Gull ruled that Allen's defense team did not produce admissible evidence that linked Odinism or specific suspected Odinists to the killings. Gull did not close the door entirely on Allen's defense, noting the court will allow Allen's attorneys to argue during trial why the evidence should be admitted. These offers of proof are done outside the presence of jurors. This means that the defense's theory of Libby and Abby's killings will not be presented to jurors, and dozens of Allen's admissions to the killings made while in isolation at a maximum security Indiana prison will be admitted into evidence. Allegations of a pagan cult aside, the filing also casts doubt on the rationale in granting a search of Allen's residence in the first place. While Sheriff Liggett applied for the search warrant in October of 2022, the defense argued that certain details described by witnesses didn't match what appeared in the affidavit. Defense attorneys said a key witness described a vehicle that looked nothing like Allen's black Ford Focus. The same witness described a man who didn't resemble Allen. That's not the same person. Those look like very different people. Her description involved a white male in his 20s with brown curly hair and a medium build, the subject of composite sketch number 2. The sketch bears little resemblance to Allen, the attorneys contend, and investigators didn't release it for more than 2 years after the killings. The original composite sketch was released within months of the Delphi murders and showed a heavier set, older individual. Nowhere in the affidavit did Sheriff Liggett write that the witness's descriptions of a person she encountered near the bridge bore little resemblance to Allen. The presence of Allen's Ford Focus is also in dispute. Allen told investigators he arrived on the trails around 12 p.m. and left around 1:30 p.m. According to the timeline set by investigators, the killings likely happened between 1:30 and 4 p.m., meaning Allen would have left, according to his recollection. A witness reported seeing a different vehicle, not Allen's Ford Focus, but rather a 1965 Ford Comet, parked outside the CPS building around 2:15 p.m. But this detail was omitted in the affidavit. A separate witness reported seeing a man wearing a tan-colored jacket, not a blue jacket. She also told investigators he was muddy. The affidavit, however, said the man was wearing a blue-colored jacket and blue jeans and was muddy and bloody, with Liggett adding the last detail, not the witness. And on October 5th, in another bizarre twist, law enforcement were notified of a leak in evidence related to the Delphi case. The evidence, including sensitive crime scene photos, had been spread online and distributed to YouTube and podcast content creators. Not this one. Mitchell Westerman, a friend and former coworker of defense attorney Andrew Baldwin, admitted to stopping by the law firm's office and found evidence photos related to the Delphi case spread out in Baldwin's conference room. He used his phone to take photographs of the evidence and then shared them with a man from Fishers, who in turn shared them with a man from Texas. The Texas man then forwarded the evidence to various YouTube and podcast creators. After being questioned by the police about the evidence leak, the Fishers man ended up taking his own life. Westerman admitted that Baldwin did not give him permission to take photographs of the crime scene evidence and that Baldwin was not present when he did so. The Delphi evidence leak caused a flood of problems for the highly publicized murder case, including playing a major role in Judge Fran Gull removing both of Allen's attorneys from the case after calling their actions grossly negligent. Judge Gull announced that Baldwin and Rozzi were voluntarily withdrawing from the case in response to the evidence leak. The decision, which the judge calls a, quote, very unexpected turn of events, meant some parts of the pretrial process would return to square one as Allen awaited a new legal team. Allen was then appointed by two new attorneys, Robert Scremin and William S. Librado, both from the same district county as Judge Gull. After their removal of the case, Baldwin and Rozzi filed several motions with the Indiana Supreme Court, claiming Judge Gull ambushed the defense team by forcing Baldwin's resignation and ordering Rozzi to do the same. They asked to be reinstated as Allen's legal counsel, while also calling for Judge Gull to be thrown from the case. Chief Justice Loretta Rush acknowledged that Judge Gull did not call a formal hearing to discuss her thinking and potential decision-making about defense counsel, which she said would have been the right process to follow. Rush wondered aloud if Gull did act beyond her authority. The Indiana Supreme Court reinstated Baldwin and Rozzi to represent Allen. Allen's attorneys first filed for Gull to disqualify herself on October 25, 2023. They filed a new motion that argued Judge Gull should be replaced or recuse herself from the proceedings in favor of a different judge. The motion questioned Gull's impartiality and ability to oversee the case without bias. Allen's attorneys have accused Gull of being biased against them by maligning them and calling them incompetent, negligent, and sloppy. Quote, at every stage from now until the conclusion of this case, the actions and rulings of the court will be scrutinized through the lens of Judge Gull's error in severing Richard Allen's attorney-client relationship with his chosen lawyers, the motion said. The attorneys argued that Gull's recusal would remove any sense of impropriety from the case. They questioned whether Gull, having removed the attorneys earlier, would be able to make rulings without the defense and the public wondering about her impartiality. The attorneys contended that Gull violated Allen's constitutional right to due process. In a 22-page affidavit supporting the motion, Allen accused Gull of misleading the public during the dramatic October 19th proceedings in which she announced that the attorneys had withdrawn from the case. He also claimed Gull interfered with his right to a speedy trial. In addition, Allen took issue with Gull's decision to deny a hearing on a Franks motion concerning the search warrant and another order concerning ballistics evidence. The rulings came just days after the Indiana Supreme Court reinstated Baldwin and Rozzi. The affidavit said Gull failed in her duty to protect Allen, who alleged mistreatment at Westville Correctional Facility. Judge Gull did not recuse herself. They filed a second motion on January 28th and a third motion May 17th of 2024. And in July of this year, they lost their attempt again. This time after going to the Indiana Supreme Court, who decided that her doing so, quote, is not warranted. Allen's attorneys argued that Gull had violated rules by failing to make decisions on 2 of the defense team's motions within the 30-day time frame, as the rules require. Because of this, the case must be withdrawn from Gull's court, and the Indiana Supreme Court must appoint a special judge. The request centers on 2 motions that were filed in March and April. The 2 motions were seeking what's called a Franks hearing, which would allow the defense team to present evidence that law enforcement made false statements in an affidavit that ultimately led to Allen's arrest in October of 2022. Months later, Gull had yet to issue a ruling. Justin Faulkner, Chief Administrative Officer to the Indiana Supreme Court, said the rules, specifically Indiana Trial Rule 53.1, no longer applies to Allen because the deadline to ask for withdrawal based on the judge's failure to issue timely rulings has passed. To successfully remove the case from Gull's court, Allen should have made the request shortly after the 30-day time frame had elapsed, not months later. Gull also heard the defense team's request to compel prosecutors to hand over documents and to sanction them for failing to do so in an organized and timely manner. Jennifer Jones-Auger, another member of Allen's defense team, said wading through 26 terabytes of data it received from the state was like looking for a needle in a haystack. I would contend that's like looking for a needle within a stack of needles. That's insane. She said hundreds of documents were labeled by numbers, making it difficult for the defense attorneys to analyze the records and build their case. McLeland said the request is moot because the state has provided defense attorneys with all the records they've requested. Quote, the data we gave is the data we have, McLeland said, adding that it is not the state's job to organize the data for the defense. We've done everything possible to make it easy for them, but here we are. Allen's attorneys want answers from law enforcement officers who refuse to answer specific questions in depositions at the advice of prosecutor McLeland. According to a motion to compel that was filed in September, defense attorneys want a straight yes or no answer from Stephen Mullen, who was Delphi police chief when Libby and Abby were killed. Mullen now is the investigator for the Carroll County Prosecutor's Office. Allen's attorneys deposed Mullen on September 13th, but he didn't answer questions that the defense wants Special Judge Francis Gull to order him to answer. Quote, is your timeline and theory of the case fatal to the prosecution's case against Richard Allen if the person Betsy Blair observed on the bridge is not Richard Allen? The motion states of a question that Mullen refused to answer during his September 13th deposition. Depositions are sworn statements from witnesses who are likely to testify at trial. Is your timeline and theory of the case fatal to the prosecution's case against Richard Allen if the vehicle Betsy Blair observed at the CPS building was not Richard Allen's vehicle? The motion asks. If Betsy Blair observed one person and Sarah Carbaugh observed an entirely different person, is the prosecution's timeline and theory of the case as it relates to Richard Allen fatally flawed? If neither Betsy Blair nor Sarah Carbaugh observed Richard Allen on February 13th, 2017, is the state's timeline and theory of the case as it relates to Richard Allen fatally flawed? This line of questioning appears to indicate that Allen's attorneys are pivoting his defense from Odinist human sacrifice to questioning the validity of the prosecutor's timeline of events. The motion to compel also asks Gull to order Indiana State Police Lieutenant Jerry Holman, former Westville prison warden John Gallipo, and Westville prison guard Sergeant Joshua Robinson to respond to the questions they declined to answer in depositions. The questions Holman refused to answer included what Holman and Carroll County Sheriff Tony Liggett spoke about in Holman's preparation for his August 10th, 2023 deposition. Allen's attorneys also want to know why investigators did not retain a blood spatter expert until April. Judge Gull has yet to make a ruling on the motion to compel. Hours before the motion to compel was filed, Allen's attorneys filed a motion asking jurors to physically visit the crime scene. Witnesses will testify about, including the old Child Protective Services buildings, where prosecutors allege Allen's car was parked between 1:30 and 4 p.m. the day the two teens were killed. The motion to view the scene includes stops walking from the Freedom Bridge, a refurbished steel girder bridge spanning the Hoosier Heartland Highway, to the Manon High Bridge, the abandoned Wood Trestle Railroad Bridge. The attorney also asked that jurors visit the killing site on the north banks of the Deer Creek, about a quarter mile east of High Bridge, and that's where the girls' bodies were found. These locations are less than 2 miles from the courthouse. Juror transport and viewing could easily be completed in under 90 minutes. The motion notes that Allen and his attorneys, as well as the prosecutors, could accompany jurors under whatever guidelines the court sets. The motion said that Allen does not have to attend if the court is concerned about security. However, prosecutor Nick McLeland filed an objection, writing that the area was difficult to traverse and the trip would require a, quote, substantial amount of time and resources. He also expressed concerns that such a trip would encroach on the private property of two landowners and noted that the area was substantially different from when Abby Williams and Libby German were killed in 2017. McLeland said the state planned to introduce numerous exhibits showing the layout of the crime scene, including maps and drone footage. He believes any benefit to having a jury visit the scene is outweighed by the dangers such a trip presents to the jury and to the fairness of the trial. Judge Gull took the defense motion under advisement pending the state's response, and a hearing is to be conducted once jury selection wraps up. Earlier, we mentioned Todd Click, a defense witness and former Rushville police officer who was part of the Delphi investigation. Click has repeatedly said he and two other investigators strongly believe at least 3 people were involved in the murders. Now he's facing felony misconduct charges related to his work as a Department of Child Services case manager. Investigators say he lied about visiting victims and families and forged signatures on paperwork. It's unclear what, if any, impact this will have on the defense's plans during the trial. For the most part, that catches you all up with everything you need to know about the Richard Allen case. The jury selection process will begin tomorrow, Monday, October 14th in Fort Wayne, Indiana. But once the jury is picked and sequestered, the trial will move to Carroll County, where the crimes happened. It's estimated the prosecution and upcoming trial of Richard Allen will cost Carroll County taxpayers more than $4 million. Unfortunately, the taxpayers and the rest of the world will not be able to watch or listen in on the trial, as no video or audio is allowed. But have no fear, Night Court is here. We will be following the case, along with many of the cases talked about tonight. Be sure to subscribe to our channel, follow us on all of the social media stuff so you don't miss an update. Now, if you want to hear the 136-page document about the defense's Odinist cult theory, I am going to be reading it in its entirety this Wednesday and probably subsequent Wednesdays on our sister show, The Transcript, which airs every Wednesday at 9 p.m. Eastern. And you can find it here on this same channel. Whew. What a case in chief, huh? I've got my main course, and now I think it's time for yes, just desserts. We don't like to, if you're new to the show, we don't like to leave it on a note like that. I want to give you some conclusions. So, if Sarah Boone and Daryl Brooks had a baby, it would be Toby Madden. On October 11th, 2022, 50-year-old Rachel Bruzaw was found dead in the home she shared with her 52-year-old boyfriend, Toby Madden. Rachel had been stabbed 55 times in her head, chest, abdomen, upper back, left knee, and both sides of her arms, shoulders, and hands. The couple had been together for 28 years at the time of Bruzaw's death. Neighbors reported that the couple had only moved into the house where Rachel had died a week before her death. That morning, between 9 to 10 a.m., a neighbor heard a scream coming from the home while she was on her porch. A patrol officer responding to a 911 call pulled Madden from the body of Rachel after she walked in on him covered in blood and performing CPR when she was clearly dead. Detective Robert Horton said Madden was distraught and crying when he interviewed him the day of the murder. He also noted that Madden had scratches and redness on his forearms and his chest. Madden told him that he woke up and found his girlfriend and told him there were 3 guys that the detective needed to find. Madden said that someone else killed Rachel because the couple confiscated drugs and there was a bounty on his head. You see, the Butler County Sheriff's Office caught him with a suitcase of more than 300 grams of methamphetamine in September of 2021. They did not arrest Madden in the hopes that he would work with them as a confidential informant and eventually tell them how he obtained the drug. However, he never contacted them again. He wasn't indicted on the drug charge until November of 2022, shortly after he was arrested for Bruzaw's murder. The next 23 months that his case had been pending were filled with multiple attorney conflicts, constant disruptiveness in court, and numerous requests to represent himself, which were denied. Madden went through 6 defense attorneys, and back in March of this year, he had to be forcibly removed from the courtroom after he threatened to assault his attorney. Madden's pretrial antics didn't stop there. His 5-day trial that began on September 23rd, 2024, was one you couldn't pull yourself away from. Before the jury members entered the room, and in a very dramatic courtroom display, Toby Madden broke down before his trial properly began. Deeply affected by the sight of his 28-year-old daughter, he appeared to inadvertently confess to the crime. Making a stabbing motion and tearfully confessing, he said, "I'm responsible for what happened to her. I didn't mean it. I love you. I don't want you to hate me." Madden had maintained his innocence up to that point, despite extensive court records indicating otherwise. The emotional scene unfolded in Butler County, Ohio, in a Butler County, Ohio courtroom with recording devices capturing the admission. Let's take a look.
We would object to that.
Listen, I don't want to object to anything. I just want to, this is about the family that I love. And, listen, yeah, I'm responsible for what happened to her and me.
Are we recording?
I believe we are.
Can we go off?
We need to take a recess?
Yes.
Okay, let's take a recess and go up.
I don't want you to hate me. I don't want you to.
All right. Prosecutor Mike Hahn told the jury in opening statements that Madden apologized for the murder before they took their seats, telling them that he made a stabbing motion with his hand in front of an entire courtroom of witnesses. He suggested the hand motion references how the victim was killed, stabbed 55 times. Madden's defense attorney opted not to give opening statements. I'll pass. On day 2 of the trial, Toby broke down several times. The most obvious display of emotion coming when prosecutors showed a photo of his girlfriend's blood-soaked body splayed across the floor, covered in stab wounds. On day 3 of the trial, forensic pathologist Dr. Russell Updegrove testified that Rachel died from multiple stab wounds, some penetrating her heart, lung, and liver. Updegrove displayed the picture of the victim at autopsy that was so shocking that someone in the gallery shouted "bastard," prompting the judge to admonish the spectators in the gallery to leave the courtroom if they could not control their emotions. Updegrove testified the wounds were consistent with being caused by a small foldable knife. Detective Doug Trenum testified that he processed a Swiss Army pocket knife found in a black backpack from the victim's house. He observed that a piece had broken off one of the blades, and there was indication that the knife had been washed. Detective Trenum also lifted what he suspected to be bloodstains from Madden's green vest and the bathroom sink. His testing of the red stains in the bathroom sink tested positive for human blood. I saw a lot of blue. Also on this day, Madden addressed the judge to complain he hasn't been able to shower in 4 days because the jail won't let him. Judge responded by telling Madden she had no control over the jail. On day 4, Detective Trenum, who helped process the crime scene, compared cuts made in the victim's shirt to a broken blade attachment of a pocket knife. The shape of the cuts in the cloth appeared to match the oddly shaped blade. The suspected murder weapon, a pocket knife, was tested for blood and DNA. No blood was found on the knife. The detective testified that it appeared to have been washed. Detective Doug Trenum used a chemical to test for the presence of blood on a gray shirt and a green vest believed to be worn by Madden at the time of the murder. Both articles reacted positively to the presence of blood. On cross, defense noted Madden's DNA was not found in the fingernail clippings of the victim and no blood was found on the knife. Madden's cousin, Tanya Cook, testified she heard Madden threaten more than once to cut off Rochelle's head and put it in her mother's lap so the whole family would suffer. On day 5, before the day's proceedings could even begin, Toby Madden complained about his defense attorney, saying he asked his attorney multiple times to put in information about how this all started, but refused to put it in, along with numerous other complaints. Toby's brother was supposed to testify for the defense, but Madden refused to allow him to testify. Madden also decided not to take the stand. Defense rested their case without presenting any evidence. After the prosecution's rebuttal argument, Madden had another outburst, because, of course he did. Let's take a look.
Thank you. Ladies and gentlemen, I want to say that.
Okay,
exhibit
jurors, I'm
number
going to ask you to
66
return to the
Exhibit 66 is the stick in there. And I also, if you look at the video of them questioning me down at the police station, if you look at it, they asked me, how did the blood get in the sink? I told them that there was blood on my face after I was doing CPR, and I told them that I went to the sink.
At this time.
Look at state number, exhibit number 66. Ask for it back there and see. There's a stick right there. They won't. There's plenty of things they won't bring to you. Ask for it. Right?
You can get them. Okay, now.
Right.
Okay, so
I look at my comment.
the court is not going to tolerate, let me get back on.
You're not, listen,
All right,
what
we're
you're
going
not
to
going
move
to
to
do
the
is I'm not
defendant to
going to
the
sit
upstairs
here
remote
and
location and
allow
take a
you to.
recess. Thank you.
This is what you did the last time when no. You want to come running down the hall?
News crew said, "Turn it back on."
You got something to say?
Well, one thing's for sure after seeing that video, I would not want to make that man mad. That is for certain. Madden was removed, as you saw, from the courtroom for the remainder of the trial. The jury, to the surprise of no one, found him guilty. Madden was sentenced immediately following the verdict. When asked if he had anything he wanted to say, he said this.
Verdict form 2, we, the jury being duly impaneled, find the defendant, Toby Madden, guilty of murder as charged in the indictment. The verdict form is signed in ink by all 12 jurors. Verdict form 3, we, the jury being duly impaneled, find the defendant, Toby Madden, guilty of felonious assault as charged in the indictment. The verdict form is signed in ink by all 12 jurors. And finally, verdict form 4, we, the jury, being duly impaneled, find the defendant, Toby Madden, guilty of felonious assault as charged in the indictment, and the verdict form is signed in ink by all 12 jurors. Okay. Verdict form 2,
Found
we, the
guilty.
jury, being duly
All right. The judge handed down the sentence of 15 years to life, with an added 10 years, meaning he will not be eligible for parole for 25 years. And hopefully longer? All right, let's move on to Preston Higgs, shall we? Liz Quackenbush, that's right, I said it, I didn't make it up, sounds like a joke. Liz Quackenbush. But that's okay, we love Liz. Liz was a well-loved chemistry teacher at New Harmony High School, known for her innovative teaching methods and her deep care for her students. Oh, she sounds lovely. She inspired her students with her outdoor adventures program, blending science and real-world experiences like gardening and kayaking. But in a senseless act of violence, her life was taken by someone she had once trusted, her boyfriend, Preston Higgs. Seen here real happy with himself, apparently. On that fateful day in March of 2021, Liz was found dead in her home on Desire Street, her body showing clear signs of a brutal attack. The weapon? An axe, which was left at the scene, adding to the horror of what authorities discovered. Authorities said the attack was merciless. The 911 call that led officers to Liz's home was made by Higgs' uncle, who had learned about the crime from other family members. According to the evidence presented at trial, Higgs didn't just flee after the attack. He was later apprehended in Indiana after an 18-week nationwide manhunt led by the U.S. Marshal Service. Higgs was attempting to evade capture using a fake ID and a burner phone when authorities finally tracked him down, further proving that burner phones are terrible ideas. It was a joke last week, but now I'm starting to think it's real. The trial itself was emotional and tense. Prosecutors presented strong evidence, including the chilling 911 call and testimony from Higgs' family members. The defense, of course, tried to sway the jury, but the evidence was overwhelming. Higgs himself even took the stand, admitting to the murder, but trying to explain his actions. While on the stand, Orleans Parish District Attorney Jason Williams asked if it was Higgs' choice to put this axe in the woman's head. Higgs replied, "Yes." "No one else?" Williams asked. "No, it was me," Higgs said. Assistant District Attorney Penny Kissinger delivered a powerful closing argument, stating, and I quote, "If the wounds to the front of her head were incapacitating, the wounds from the back must have come first. Preston Higgs is a liar. There is no reasonable doubt that he murdered Elizabeth Quackenbush." After 3 days of testimony, the jury returned with a guilty verdict for second-degree murder. Does a body good to see bars in front of that face. For Liz Quackenbush's family, the trial was excruciating. Imagine sitting in that courtroom day after day, hearing the brutal details of your loved one's murder. Family members read heart-wrenching victim statements, with many reminiscing about Liz's incredible spirit and the huge hole left in their lives. Her family wore purple at the sentencing, a tribute to Liz's favorite color and a symbol of Domestic Violence Awareness Month. Liz's sister-in-law calling her the strongest woman she knew, and a friend spoke directly to Higgs, telling him, "You, Preston, took our beloved friend." Orleans Parish Judge Ronna Good Douglas said, "For you to take Miss Quackenbush out like this was just so unnecessary and evil. With that, Mr. Higgs, you will spend the rest of your life in the Department of Corrections." On October 3rd, Preston Higgs was sentenced to life in prison without the possibility of parole or a suspended sentence. And after that, let's get into our closing arguments. Well, that was another wild night in the courtroom, eh? Let's just take a couple of minutes to reflect on what we've just witnessed. We had Sarah Boone, whose next boyfriend hopefully won't find her baggage as suffocating as her last. And then we had Sean Diddy Combs, yes, Diddler himself, who managed to remind us all that the mo money we come across, the mo dildos and lube and legal problems we see. In the words of Tupac, revenge is the sweetest joy next to getting... yeah, quote ends there. Well, it looks like karma can't be paid off anyways, and it has better lawyers than we thought. Now, if you need proof that bad decisions are universal, take a look at Leilani Simon. When your life strategy is, let's just see how this all plays out, I'm thinking, maybe don't. And then, of course, Melody Walker Ferris, who made Florida proud yet again. Seriously, is Florida outsourcing its headlines to Tubi or something? And now let's just talk about Richard Allen, which is as mysterious and convoluted as Zeus's dating history. Ooh, wrong pantheon. But this case is low-key wild. From the possibility of other assailants, false confessions, the Odinite conspiracy, and a defense witness that CPS took their credibility away, this case continues to have more twists and turns than the best roller coasters. With the defense relying on human sacrifice for Odin theory, I'm surprised there hasn't been someone in the courtroom holding a hammer screaming, "For Asgard!" Why did he sound like a pirate? I don't know. I don't do Odin. Okay. But yeah, holding a hammer, screaming for Asgard, and getting the Valhalla out of there. Seriously, though, I haven't seen followers of Odin do this much damage to a defense since the last season of Vikings. Then, of course, Toby Madden or Preston Higgs, who, well, at least they aren't blaming it on Odin, so I guess they got something that going for them anyways. But seriously, when you think about it, this show, these cases, what's the common thread? People making incredibly bad decisions, and the justice team trying its best to keep up. Whether it's a celebrity in trouble, a suitcase homicide, or, let's be honest, the fact that Odin has somehow been pulled into our criminal justice system, it just goes to show how bizarre and unpredictable life and court can be. So my final thought is this. If you ever find yourself in a situation where the only defense you have is, Odin told me to do it, it might be time to reassess. And if you're considering packing up, just read the instructions on the side of the suitcase. Now, if you enjoyed tonight's episode, make sure to hit the like button. And if you want to see more of our content, subscribe to our channel and turn on the notification bell to not miss out. We would love to hear your thoughts and opinions on this week's trials. It's evident that I'm opinionated. I want to hear yours too. Who do you think's guilty? Who do you think is innocent? Leave the comment down below to let us know, and follow us on social media for more updates during the week and free behind-the-scenes content, which is usually me being like, oh my God, I forgot everything, and then my team has done it all because they're amazing. Be sure to tune in next week when we will continue our coverage of the hottest true crime and trial updates and take a deep dive into the case of Georgia v. Leilani Simon. I am JT, and I'll see you all next Sunday at 8 p.m. Eastern, 7 p.m. Central. Real quick before I close, just thank you to producer Tara and for our researcher, Amy. Without them, this show this weekend would not have happened because my brain was apparently in so many different places. It wasn't where it needed to be. So thank you to both of you. Also, side note, thanks to B for writing some of the stuff that's in here too. You surprised me and made me chuckle like I was laughing at my own stuff. Anyways, thanks everybody for tuning in. I appreciate it. Until next time, stay safe out there and shine on, you night owls.